Good morning. Good morning again. Douglas Eng on behalf of TMT. I want to cover four areas in my argument with you today. First, I want to highlight the efforts that TMT has made over the years in seeking this permit. Second, I briefly want to discuss the evidence as it relates to cultural practices. Third, I want to highlight the law with regard to religious freedom. Finally, I want to explain to you why the Establishment Clause of the Constitution prohibits this board from taking actions which respect or seek to promote one religion over all others. So first, we have been in this entitlement process for over 10 years now. Enormous resources have been spent in this regard. When TMT began its effort to seek this entitlement, it decided to pursue a new model for development of astronomy facilities at the summit of Mauna Kea. It wanted to become a part of this community. Through the EIS process and multiple community meetings, it sought guidance from the broader Hawaii Island community. It learned the values of this community. And TMT strived to develop this project respecting those values. And it made substantial commitments in the process. First, the project committed to paying substantial sublease rent. No other astronomy facility at the summit of Mauna Kea pays this rent. TMT understood that these rent monies were needed to fund management of the mountain. Sublease rent payments begin at $300,000 per year, and they gradually ratchet up to in excess of $1 million a year in the 11th year. Second, TMT sought to become a voice for STEM education, science, technology, engineering, and math. It committed to funding $1 million annually through the Think Fund for STEM education purposes. And while TMT lost its permit in December of 2015, through no fault of its own, it continued those payments because it was a commitment to the community. Third, TMT did not stop with just sublease rent and the Think Fund. It committed to additional community benefits in the way of a substantial workforce pipeline program and assistance to Imiloa. These efforts focus on education, training, and development of job-related skills. All of these efforts were an effort to break from the past model of development of observatories. TMT realized that this was about building relationships and creating hope and aspirations for the future generations of Hawaii Island. We stand at a dual threshold of discovery and opportunity. The stakes are monumental. If this project is denied, so will the hopes and aspirations of many on this island. We encourage you and urge you to approve this permit. Secondly, I want to go into the evidence with regard to cultural practices. The evidence is demonstrated, and this is set forth in enormous detail in Judge Amano's findings, that astronomy development has not impacted cultural practices. If you look at the evidence and you read the testimony of the interveners and their witnesses very carefully, you will see that their practices have continued since the 1990s, and in fact, in some cases, have increased at the summit, in spite of the presence and development of astronomy facilities. It is very important to distinguish religious beliefs from religious practices, because the law treats them differently. Freedom of individual beliefs is absolute. Freedom of individual conduct is not. And it is that conduct piece that applies to cultural practices. Interveners have testified that their practices continue to the present day, even in the presence of these astronomy facilities. Well, any case testified that she has been practicing at Mauna Kea since 1991, and in fact her practices have increased since the year 2010, even in the presence of the telescopes. Kalani Flores testified that he's been practicing at Mauna Kea since the early 1980s, even though he considers the area substantially developed. Kealoha Pashota has testified that she's been practicing at Mauna Kea since the 1990s, and that her practices have actually deepened since that time. And she admits that these practices have been extensive, but also have been conducted in the presence of these astronomy facilities. Kahu Frank Nobriga has also testified that he's been able to continue his practices despite the presence of these observatory facilities. All of these practices have been described in great detail. They are in the record. All of them have been conducted in the presence of these facilities. There is no rational reason why their practices cannot continue, even if TMT is developed. Third, I want to move on to the area of religious freedom. Belief in an area's sacredness does not make development of that area an infringement on religion. It does not give the believer a legal right to stop development. And I cite the Ling case versus Northwest Cemetery. That case is well briefed in Judge Amano's proposed findings and conclusions. The analysis must instead focus on infringement of religious practices, not beliefs. Constitutional protection means protection against unreasonable interference with religious practices, not beliefs. It does not prevent interference with religious beliefs. Even if a proposed government action would adversely affect claimants, interveners, religious practices, the right of the free exercise of religion is not violated. Petitioners and interveners claim that their beliefs give them a veto power over any proposed development at the summit. The law does not support that view. The board's approval of the project here does not and will not unreasonably interfere with the intervener's free exercise of religion. Finally, I want to talk about the Establishment Clause. So why is this important? It's important because much of the testimony about Mauna Kea centered around its sacredness. Wauakua, as many have referred to the summit area. The First Amendment of the United States Constitution provides that Congress shall make no law respecting an establishment of religion. The interveners would have you believe that they have a right, because of its sacredness, to stop construction. They do not. The free exercise clause is limited by the establishment clause. Denial of this permit based on the assertion of harm to religious beliefs contravenes the fundamental purpose of preventing the state from fostering the support of one religion over others.
Thank you. Thank you.
Time's up right now. Okay, thank you. In conclusion, for all the reasons I've stated, this board should grant the permit. There is no rational reason why their religious rights will be affected by the development of the project. Thank you.
Thank you.
Yeah, I want to cover 4 areas very quickly, and then one other area. First, in Connie Flores' argument, he stated that there were traditional and cultural practices that occur on the Northern Plateau. Okay. What he failed to do, though, is to point out in the record, evidentiary record, where the elements of both the Pash case as well as the Hanapi case have been met in the record, and they have not. The second, Mr. Nevis talked about cultural practices and the fact that on the 22nd for the solstice he was going to Kukaha'ula, summit of Mauna Kea. But what he did not explain to you was how TMT in any way would prevent him from doing that, and it would not. So even if TMT were built, he can still make that journey at the solstice. Third, I want to address some of the comments of Mr. Kayama. First, that motion to dismiss that he filed, TIO did file a memo in opposition. It is document 148. That was filed on August 1st, 2016 at 2:36 p.m., and we did oppose substantively that motion. So you can disregard what he said about that motion to dismiss. Fourth, Mr. Kayama stated that Judge Amano's decision was wrong because it failed to consider the summit as a part of the public trust document. That is not what Judge Amano's decision provides. If you refer to conclusion of law 315, she states there, accordingly, for all the reasons herein, although the privately operated TMT project involves the use of government land, the proposed use is consistent with the public trust doctrine, regardless of whether the TMT project is construed as public, quasi-public, or a private use of land. In other words, she's saying that given the public trust doctrine considerations, TMT still qualifies for a permit in this project. She goes on to state at conclusion of law 327, viewed in light of the public trust obligations described above, the implementation of those obligations through HAR 13530, subparagraph C, the TMT project satisfies all public trust legal obligations, and it is the most equitable, reasonable, beneficial allocation of state trust resources. Finally, I want to talk a little bit about TMT. TMT, as an observatory, will seek light, distant light, whether from stars, the Big Bang, or billions of years ago. It wants to do this from the very best location in the world to do this, Mauna Kea. And it's not just the light rays and wavelengths absorbed. It's about the knowledge that comes from that light. Knowledge about how stars are formed. Knowledge about how the universe was formed. Knowledge about how stars die. Knowledge about how someday Earth may perish. It is science and it is education, but fundamentally it's about knowledge. It is a quest for knowledge. Astronomers are people too. They too follow the winds of their souls. They are protectors. They protect the quest for knowledge. They are voyagers voyaging back in time in a quest for knowledge. They are on a mission. They're on a mission of discovery and understanding. They search not for islands. They search for knowledge, and they search for the origin of life. So let's continue this pursuit. Let's reach to the stars. I urge you to grant this permit. Thank you.
The telescope itself, would it be, like in certain areas, say like on Kauai, they build one hotel, we limit it to 4 stories, but they'll build them on the side of the hill, and they take the 4 stories from the top of the hill, but they build a hotel down. Would that happen over there? Or is it? They cannot do that? Oh. No, you know what I'm trying to say is that you're going to build it on the side. So you take would a telescope go below the slope, or would it be all up here, above the ground? Like Mr. Flores saying it would be.
Yeah. So from the ground level, I believe it goes up 184 feet. It also goes down about 20 feet, and the numbers are actually in the record. I'm just recalling generally what those numbers are.
No, that's the only question. I was wondering, it's for 180 feet, that's going to be a sort of an eyesore, being above the ground.
Right. But
so I thought because you're on the slope, you would put a portion of it above the ground and portion of it below the ground, but I guess not.
So for the telescopes itself, and I think this came out in some of the testimony, the mirror structure has to be above ground. Otherwise, you're subject to heat gradients between the ground and the level of the mirror, and it will interfere with the scope's ability to receive light.
Okay, the second question is
just to clarify, I'm going to use your mic. So, just to clarify, do you have height limits, a height altitude limit, I guess, of the top of the TMT compared to the other telescopes that are there already?
There's no height limit per se.
I don't mean a height limit. What is the top of the telescope altitude of the TMT compared to the other existing telescopes?
It's well below that, I believe, in the order of 100 feet below. So if you go to the summit, which is at 13,790 feet, Subaru goes up 150 feet. It's not actually at the summit. Gemini is on the summit. It goes up 100 and not on the summit, 140 feet, something like that. So those observatories are up at the summit, at that elevation. The ground elevation where the TMT will be built is about 13,000, I want to say, 200 feet. And that elevation is actually in the record as well, so it can be verified.
And, they talked about the FONSI. The FONSI was done for the specific site itself, wasn't it?
There was no FONSI issued, so we went straight from a notice of ESPIN to an environmental impact statement. There was no FONSI issued.
Okay, but the EIS was done for the specific site, the area of the site, not expanding outside the site.
It definitely included all of the 5-acre site, the 3-acre roadway, access way, as well as the batch plant area, about 4 acres, because that's required. And so it did look at that, but it didn't stop there. There were studies that were done beyond that. So if we're talking about flora, fauna, archaeology, those studies went beyond the actual site itself.
And no archaeologists, historical sites were found on the property then?
That is correct. No historic sites were located on the property.
All right, that's it. Thank you.
And one of the things I'd like to say is I'd like to thank everyone for coming out today. I feel, hear your compassion, issues. I think is a very good round of discussions we had. I totally am on the fence with all of this because it's a very hard decision on both sides. Somebody will lose, somebody will win, but maybe everybody will lose. I can hear you, I feel you. It's very hard for me, but I want to say thank you to all of you who have come out today and take off time from work and give us a special time. For you, sir, some of the things you said in your testimony was it's been a making of 10 years to get this entitlement. And the sublease rent to fund management comes in about $300,000. Is that correct?
Initially, yes.
Initially.
And in the rental agreement, sublease rental agreement is in the record.
Okay. And the STEM education is $1 million. Is that?
STEM education is $1 million a year, yes.
A year. And this would go to build what kind of relationship?
The STEM fund has been split, and this is in the record as well, in the testimony of Gary Saunders. $750,000 of it goes to the Hawaii Community Foundation. $250,000 goes to the Pauahi Foundation. So those are professional fundraising organizations. They will receive applications from applicants, and it could be a student, it could be a teacher, it could be someone, robotics, for example, for funds from these. Now, those are placed with those entities because they're professional fundraising organizations. They have the ability to grow those funds so that while they start with $1 million in total, others contribute to those funds for STEM education. So the funds actually grow as they sit there.
And this will be determined by whom? I mean,
the Pauahi Foundation will determine who gets the grants for STEM education. Those are designed because that's an entity, so not for profit, but it's under the Kamehameha Schools umbrella. Hawaii Community Foundation will receive the applications and it will distribute the funds. And geographically, those funds are focused on Hawaii Island.
Just Hawaii Island, none of the other islands are subject to any of this?
I don't recall, but what I believe is that the funds are focused here. I don't know whether all of it ends up here. You do send students to college, so they relocate and they go to school for 4 years as a result of a scholarship that comes from this fund.
Okay, thank you.